In this presentation, you will learn about parent and child's rights as afforded under the Individuals with Disabilities Education Improvement Act of 2004. This presentation includes the 2012 revisions. Procedural safeguards identifies key parts of the Individuals with Disabilities Education Improvement Act of 2004, also called IDEA 2004, a federal law governing the education of students with disabilities. IDEA 2004 requires that families be informed of their special education rights, including how families and schools can resolve problems. Some of your basic rights include prior written notice to be given in writing about the LEA or local educational agency's actions which involve your child's educational needs. This information will assist you in providing informed consent for educational decisions. You have the right to have information in a language you understand. If offered by your LEA, you have the right to choose to get information by email. You have the right to allow information to be shared or certain actions to be taken, and you must be told of that right in a language you understand. You have the right to take away or revoke your consent. Your LEA must give you written notice whenever it proposes to initiate or to change the identification, evaluation, or educational placement of your child or the provisions of a free appropriate public education, FAPE, to your child, or refuses to initiate or to change the identification, evaluation, or educational placement of your child or the provision of FAPE to your child. The prior written notice must describe the action that your LEA proposes or refuses to take. Explain why your LEA is proposing or refusing to take the action. Describe each evaluation procedure, assessment, record, or report your LEA used in deciding to propose or refuse the action. Include a statement that you have protections under the procedural safeguards provisions in IDEA. Tell you how you can obtain a description of the procedural safeguards if the action that your LEA is proposing or refusing is not an initial referral for evaluation. Include resources for you to contact for help in understanding IDEA. Describe any other choices that your child's individualized education program team considered and the reasons why those choices were rejected, and provide a description of other reasons why your LEA proposed or refused the action. You have the right to be given written information about the LEA's actions which involve your child's educational needs. The information will assist you in providing informed consent for educational decisions. The notice must be written in a language understandable to the general public and provided in your native language or other mode of communication you use, unless it is clearly not feasible to do so. And for a person with deafness or blindness, or for a person with no written language, the mode of communication is what the person normally uses, such as sign language, braille, or oral communication. If your native language or other mode of communication is not a written language, your LEA must ensure that the notice is translated for you orally in your native language or other mode of communication. You understand the content of the notice, and there is written evidence that both of these conditions have been met. If offered by your LEA, you have the right to choose to get information by email. If your LEA offers parents the choice of receiving documents by email, you may choose to receive the prior written notice, procedural safeguards, and/or notices related to a request for due process by email. You have the right to allow information to be shared or certain actions to be taken, and you must be told of that right in a language you understand. You have the right to take away or revoke your consent. Consent means you have been fully informed in your native language or other mode of communication of all information about the action for which you are giving consent. You understand and agree in writing to that action, and the consent describes that action and lists the records, if any, that will be released and to whom, and you understand that the consent is voluntary on your part and you may withdraw your consent at any time. Your withdrawal of consent does not negate or undo an action that has occurred after you gave your consent and before you withdrew it. Your LEA cannot conduct an initial evaluation of your child to determine whether your child is eligible under IDEA to receive special education and related services without providing you with prior written notice of the proposed action and obtaining your consent. The LEA must make reasonable efforts to obtain your informed consent before providing special education and related services to your child for the first time. Your LEA must obtain your informed consent before it reevaluates your child unless your school can demonstrate that it took reasonable steps to obtain your consent for your child's reevaluation and you did not respond. You have the right to revoke your consent for your child to continue receiving special education and related services at any time. Such revocation of consent applies to all of the special education and related services that your child is receiving. If you disagree about a particular service, you may address this issue with your child's IEP team, and if the issue remains unresolved, mediation and due process are available options to resolve the matter. The procedural safeguards notice must include a full explanation of all of the procedural safeguards available. These include independent educational evaluations, IEE, confidentiality of information, alternative dispute resolution, procedures when disciplining children with disabilities, requirements for unilateral placement by parents of children in private schools at public expense. You have the right to an independent educational evaluation of your child at public expense if you disagree with an evaluation of your child obtained by your LEA subject to the following conditions. If you request an independent educational evaluation of your child at public expense, your LEA must, without unnecessary delay, either file a request for due process to request a hearing to show that its evaluation of your child is appropriate, or provide an independent educational evaluation at public expense unless the LEA demonstrates in a hearing that the evaluation of your child that you obtained did not meet the LEA's criteria. If your LEA requests a hearing and the final decision is that your LEA's evaluation of your child is appropriate, you still have the right to an independent educational evaluation, but not at public expense. If you request an independent educational evaluation of your child, the LEA may ask why you object to the evaluation of your child obtained by your LEA. However, your LEA may not require an explanation and may not unreasonably delay either providing the independent educational evaluation of your child at public expense or filing a request for due process to defend the LEA's evaluation of your child. You are entitled to only one independent educational evaluation of your child at public expense each time your LEA conducts an evaluation of your child with which you disagree. If you obtain an independent educational evaluation of your child at public expense, or you share with the LEA an evaluation of your child that you obtained at private expense, your LEA must consider the results of the evaluation of your child if it meets the LEA's criteria for independent educational evaluation in any decision made with respect to the provision of a free, appropriate public education to your child, and you or your LEA may present the evaluation as evidence at a due process hearing regarding your child. Procedural safeguards also guarantees your child's records be kept confidential. You have the right to be told by the state about how your child's information will be used and kept confidential by the state and the LEA. You have the right to review your child's records. If your child's education record is seen by someone other than you or an employee of the LEA, the school that maintains your child's record must keep a record of who saw your child's record and when and why they reviewed it. You have the right to ask that your child's education record be changed if you think the record is not correct or that it violates your child's privacy. You have the right to a hearing if your request to have your child's education record changed is denied. You have the right to have your child's education record changed as a result of a hearing or to include a statement in the education record noting that you disagree with information in the record. You have the right to consent to release information that it identifies your child. You have the right to expect that your LEA will keep your child's education record confidential. The LEA must make mediation available to allow you and the LEA to resolve disagreements involving any matter under IDEA, including matters arising prior to the filing of a request for due process. Mediation is available to resolve disputes under IDEA, whether or not you have filed a request for due process. The mediation process must be voluntary on your part and the LEA's part, is not used to deny or delay your right to a due process hearing or to deny any other rights you have under IDEA, and is conducted by a qualified and impartial mediator who is trained in effective mediation techniques. In addition to mediation, you have the right to use the state complaint process to resolve disagreements with the LEA. You have the right to file a complaint, but your complaint must contain specific information. A statement that a LEA has violated a requirement of IDEA or its regulations, the facts on which the statement is based, the signature and contact information for the complainant, and, if alleging violations regarding a specific child, the name of the child and the address of the child's residence, the name of the school the child is attending. In the case of a homeless child or youth, available contact information for the child and the name of the school the child is attending. A description of the nature of the problem of the child, including facts relating to the problem, and a proposed resolution of the problem to the extent known and available to the party filing the complaint at the time the complaint is filed. You have the right to ask for a due process hearing if you and the school cannot agree about your child's education. You have the right to receive information about free or low-cost legal help. You have the right to have the request kept confidential. You have the right to have a response to your request. Except in specialized circumstances, your child has the right to continue getting the same educational services until the due process is resolved, unless you and the LEA make a different agreement. You have certain guaranteed rights during the hearing process. You have the right to have a due process hearing by a knowledgeable hearing officer who is not employed by the LEA. You have certain rights during due process hearings, including the right to have access before the hearing to all of the evidence that the school will use during the hearing, to have a lawyer or other persons helping you, to have a record of the hearing at no cost, and to have the hearing open to the public. You have the right to have the hearing at a time and place that is convenient to you, to have a final decision in the hearing within a set timeline, and to receive a copy of the decision. You have the right to have a decision based on the issues in your due process request, to file a separate due process request if new issues arise, and to have information that specifically identifies your child removed from the hearing decision before the decision is made public. A court may decide that the losing party must pay the other party's legal fees. You have the right to respond to certain disciplinary actions taken with your child. If your child breaks school rules, your child's educational placement may be changed. School personnel may consider any unique circumstances on a case-by-case basis when determining whether a change of placement is appropriate for a child with a disability who violates a school code of student conduct. To the extent that they also take such action for children without disabilities, school personnel may, for not more than 10 school days in a row, remove a child with a disability who violates a code of student conduct from his or her current placement to an appropriate interim alternative educational setting, another setting, or suspension. School personnel may also impose additional removals of the child of not more than 10 school days in a row in that same school year for separate incidents of misconduct, as long as those removals do not constitute a change of placement. Once a child with a disability has been removed from his or her current placement for a total of 10 school days in the same school year, the LEA must, during any subsequent days of removal in that school year, provide services to the extent required. A removal of a child with a disability from the child's current educational placement is a change of placement if the removal is for more than 10 school days in a row, or the child has been subjected to a series of removals that constitute a pattern because the series of removals totals more than 10 school days in a school year, the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals, and of such additional factors as the length of each removal, the total amount of time the child has been removed, and the proximity of the removals to one another. Within 10 school days of any decision to change the placement of a child with a disability because of a violation of a code of student conduct, the LEA, the parent, and relevant members of the IEP team must review all relevant information in the student's file, including the child's IEP, any teacher observations, and any relevant information provided by the parents to determine if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or if the conduct in question was a direct result of the LEA's failure to implement the child's IEP. If your child's behavior involves illegal or controlled drugs, a dangerous weapon, or serious bodily injury, the LEA has greater flexibility to discipline your child. You have the right to file for a due process hearing if you disagree with the LEA's decision when disciplining your child. When the parent or LEA has filed a request for due process related to disciplinary matters, The child must, unless the parent and LEA agree otherwise, remain in the interim alternative educational setting pending the decision of the hearing officer or until the expiration of the time period of removal, whichever occurs first. If a child has not been determined eligible for special education and related services and violates a code of student conduct, but the LEA had knowledge before the behavior that the child was a child with a disability, then the child may assert any of the protections described in this notice. An LEA must be deemed to have knowledge that a child is a child with a disability if, before the behavior that brought about the disciplinary action occurred, the parent of the child expressed concern in writing that the child is in need of special education and related services to supervisory or administrative personnel of the appropriate educational agency or a teacher of the child. The parent requested an evaluation related to eligibility for special education and related services, or the child's teacher or other LEA personnel expressed specific concerns about a pattern of behavior demonstrated by the child directly to the LEA's director of special education or to other supervisory personnel of the LEA. You may have the right to certain services when you independently place your child in a private school. However, IDEA does not require an LEA to pay for the cost of education, including special education and related services, of your child with a disability at a private school or facility if the LEA made a free, appropriate public education available to your child and you choose to place the child in a private school or facility. If your child previously received special education and related services under the authority of an LEA and you chose to enroll your child in a private preschool, elementary school, or secondary school without the consent of or referral by the LEA, a court or a hearing officer may require the agency to reimburse you for the cost of that enrollment if the court or hearing officer finds that the agency had not made a free and appropriate education available to your child in a timely manner prior to that enrollment and that the private placement is appropriate. The procedures that relate to gifted students are the same as school-age children with disabilities, with 4 exceptions. The 4 exceptions include: child find requirements are not required to be met, disciplinary changes of placement may or may not apply, transition planning is not required, free appropriate public education, FAPE, is not guaranteed. Thank you for watching this presentation. You may click the pause button in the lower left to take a moment to write down any of these resources you may need. You may also visit the Rio Rancho Public School website for more information.